Hello and welcome to McKenzie Friend. Today we're going to talk about denigration, social media, publication and Section 121 of the Family Law Act. But first, the usual disclaimer. Whilst I hold a law degree and major in family law, I do not practice nor seek commission. This video is for information purposes only. Any specific questions should be directed towards an accredited specialist lawyer. Okay, let's talk about denigration or commenting on your ex with regards to family law proceedings. I think it's pretty basic to say that assume that everything you put in writing can be used against you in family law proceedings or protection order applications. Now, denigration. Under the Family Law Act in Section 4AB to D in the definition section, repeated derogatory torts are considered to be an example of family violence. Example of denigration orders may include: each of the parties are hereby restrained from denigrating the other party's spouse and or partner or immediate family in the presence or hearing of the children, or allow or submit to any other person doing so. Or it might say, each party is restrained from denigrating or criticising the other in the presence or hearing of a child, and from permitting the child to remain in the presence or hearing of another person denigrating the other. Now let's look a little bit of judicial commentary on this. This is from a very good book called Inside Family Law, Conversations from the Coalface by Zoe Durand. This is comments from Federal Circuit Court Judge Stephen Scarlett. He says, a lot of litigants don't realise that what you SMS or put in an email is not ephemeral. What he means, it's not temporary, it's there forever. So many times you go to court and there would be howls of outrage from one side because the other party made comments about them on Facebook. It was never conducive to settlement. Social media has affected what has come into courts. My advice to litigants is don't post anything off Facebook that is relevant. Resist the temptation. If your former partner has access to passwords for your email, tell them they can no longer use the password, but change it anyhow. You do get people trying to hack each other's emails. These are comments from His Honour Justice Peter Rose. The only advantage of social media that I can think of is an avenue to find a missing child. Text messages should be limited to arrangements and constructive or positive comments. Anything else should remain in the mind. This is some advice from David Barry, who's a barrister. Assume everything you put in black and white anywhere at any time is capable of being accessed and shown to the person who may ultimately decide what is best for your child. From lawyer Joanna Knight. Social media can be tricky. My advice is to say as little as possible. Even if you have tight privacy settings on your account, things might still be visible. Now, in courts, we have a policy of open justice, which is reflected in 97 of the Family Law Act, which provides that all proceedings should be heard in open unless the court decides otherwise. However, family law proceedings involve children, and that requires a balance to be struck between the need for open justice and a family's right to privacy. This is where Section 121 comes in. Section 121 provides that a person who publishes in a newspaper or periodical publication by radio broadcast or television or other electronic means, or otherwise disseminates to the public or section of a public by any means, any account of proceedings or any part of any proceedings under this Act identifies a party to proceedings, a person who is related to or associated with a party to proceedings, or is alleged to be in any way concerned in the matter to which proceedings relate, or a witness in proceedings, commits an offence punishable upon conviction by imprisonment for a period not exceeding 1 year. So there's serious penalties for people who disseminate information about family law matters. Whilst this predominantly focuses on the media as such, this still relates to people and postings on social media. Let's look at some case law. This is a case on Re Edelson ex parte Donnelly by Justice Morling. He said, in the context of Section 121, disseminates to the public should be taken as a reference to widespread communication with the aim of reaching a wide audience. It could not have been intended by a legislator that the restriction on dissemination should apply, for example, to conversations between a party to family law court proceedings, and a close personal friend. So he's saying it's okay to talk to close personal friends. However, in Lackey and May in 2013, His Honour Federal Magistrate, now Judge Neville, stated at paragraphs 9 and 10 of his judgment, an unfortunate and increasing feature of modern litigation, particularly but not exclusively in family law, is the use of social media. While it can be used for good, often is used as a weapon by one or both of the parties, and or by their respective supporters. It is a veritable Aladdin's cave which parties and lawyers readily and regularly explore for invariably incriminating evidence to be used in litigation. As a weapon, it has particularly insidious features. Unfortunately, in the context of this matter, netiquette was not on display, and in fact, it could only be nothing more than a euphemism for outlandish electronically fomented conduct. In this matter, the father and the members of his family posted comments on Facebook about his family law court proceedings. The father was warned that he risked penalty for breaching 121 by publishing details of the current proceedings. Despite the warning, the father continued to post comments on Facebook, including comments that criticised His Honour Judicial Officer presiding over his case. It is never a good idea to make negative comments about a judge or any officers of the court during proceedings. His Honour made orders that the father and members of his family were restrained from publishing or otherwise distributing any material relating to the proceedings. The children, the mother, or members of her family, including publication on Facebook or other social media site. The father was ordered to remove all references to the proceedings from Facebook. The court went further. Orders were made pursuant to Section 121 that the judgment and all affidavits and exhibits made available to the court martial and the Australian Federal Police, and that the marshal monitor social media for postings made by the father or his family for the next 2 years. The marshal was directed to investigate breaches of 121 and investigate and prosecute if appropriate. So, how to vent? Never in writing. Just never put anything in writing anywhere. In SMS, email, Facebook, never. Be very careful on social media. It's not unusual for social media posts to be screenshot and evidenced in affidavits. If you have to vent, then to a close personal friend who you trust, and just hope that it doesn't get back to the other side. You can vent to your lawyer because there's issues of confidentiality, and also support groups. Like, for example, Dads in Distress. They have meetings in most capital cities on a weekly basis. And if you really feel you need to vent to other people, then this is a great avenue. So in conclusion, don't post anything on social media that you would wish not to be evidenced against you in court. Hope this helps.